Hi, everyone. I'm Ellen Shutt, Executive Director of GoEd, and I'm here today with two partners at Amin, Talati, Wasserman. This firm has been working with GoEd for many years, and we thought it would be a good idea to have a conversation about some of the legal challenges that our members might face and get some free advice on what you might want to do if you encounter one of these sticky situations. So I'm here today with Peter Paredes and George Spatz. Thank you very much for joining us.
Thank you.
Great. Nice to be
And
here.
And so we're going to talk today about IP, intellectual property and patents, supply chain disputes. Let's dig in and start with the IP and patent world. So the first question is, how do you decide between a patent and a trade secret? And Peter, I'll ask you this question.
Great. Thank you, Ellen. So just a little bit about trade secrets and patents as a background. A trade secret is any information such as a secret sauce, formula, or manufacturing process, which is not generally known to the public or readily ascertainable. You must maintain this information as a secret. So through normal business practices, confidentiality agreements, and the like. And you can maintain this as an intellectual property asset as long as it's maintained as a secret. And this is kind of in contrast to patents, where you have to fully disclose your idea or invention to the US or foreign patent office. And so it's the enablement requirements in which you exchange your idea in order to provide protection or a limited monopoly on your idea for 20 years, which is 20 years from the filing date in the US. In order to obtain a patent, it does take some time to meet the usefulness and non-obviousness requirements. But in terms of the US, it is a first to file system. So whoever files their invention first within the US and foreign jurisdictions has priority to that invention. Competitors, again, can challenge the validity of your patent once it's issued. But oftentimes what happens with industry and nutraceutical companies is they begin to either publicly disclose or sell their product before they've actually filed it. So this would defeat your patent rights if you offer to sell or publicly disclosed your composition before filing for your patent. And the key consideration with patents and trademarks is the process or composition readily reverse engineered? Can somebody take the composition and apply certain tests and analysis to determine the chemical composition, whether it's percentage of chemicals or the formulation? If it is readily reverse engineered, we advise our clients, look to possibly patenting this because someone can basically take your composition and reverse engineer it. And if it's more towards a manufacturing process and it cannot be reverse engineered, according to one of your skill in the arts, we advise them to seek trade secret protection. So have certain confidentiality and employment agreement provisions in place to ensure that that information is on a need-to-know basis.
So a question that always comes up in our world, can you patent a natural product?
Yeah, that's a great question. And so back in 2013, the Supreme Court came down with a decision saying that naturally derived products or naturally isolated products are not patentable. And so this is where sometimes trade secret is more valuable for some natural products, whether it's a secret sauce or a secret or a specific proprietary manufacturing process for that natural product. So trade secret is still available to protect those natural product formulations. Now, if you add some different structure, synthetic structure to the chemical compound, in addition to the natural product, then you can patent that with the US Patent Office. But oftentimes, some of our clients look to method of treatment claims. So if you're using a natural product to treat some type of health condition or a disease state, and you've got proof with that natural product, you can then file method of treatment claims in the US. So this is often the times where when you go into international protection, the different laws in US, Europe, and Japan kind of segue into different areas, because in Europe, you cannot patent method of treatment claims because it's basically any use for an invention on a human, like a surgical product or a therapeutic, is not allowed under their laws, their patent laws. So you basically try to file composition claims in Europe, and the natural product restriction isn't as great in Europe and Japan as well. So there's ways to go about it in different jurisdictions to protect natural products.
So it matters a lot where you're starting from. So last question on the patent topic, how important is establishing freedom to operate when you're launching a new product? And can you just explain what freedom to operate means in case the audience doesn't know?
Sure. So freedom to operate generally encompasses whether you're making and selling your product is essentially free from any liability or legal claims. So that can encompass patent claims, trademark claims, but it also goes into the realm of regulatory, statutory regulations, and compliance with any contractual matters you may have. So when going in for freedom to operate in terms of patents and trademarks, there's typically a search that's conducted to make sure you're not infringing on any other competitors' patent rights or trademark registrations in the US. Again, you should consider your contracts with your suppliers and manufacturers to understand any liabilities or restrictions that may be covenanted under those agreements. So there's no guarantee with any freedom to operate that you'll be absolutely free and clear, but it's often important with investors and corporate partners who look to either invest in your product or partner with your company that an initial freedom to operate search has been completed in order to ensure that the due diligence is satisfied on both parties. The freedom to operate opinion itself is one way to insulate your company from liability. If you have any type of infringement action brought against you, you're insulated from willful infringement to lower your risk of paying treble damages. And just one point of confusion with some companies is if you have a patent or trademark registered, it does not protect you or provide freedom to operate. So it's often two sides of the coin of having a sword versus a shield with a patent versus a freedom to operate.
Okay, yeah, good visual. So you mentioned partners and supply chain in particular. So let's give the microphone to George and talk about when you are concerned about supply chain disputes. What are some of the issues you should be thinking about?
Yes, thanks, Ellen. For supply chains disputes, it's often a backwards thinking to business people, where business people always are thinking forward. And what's going to happen when you get into a dispute, courts and a jury, it's a post-mortem and it's backwards looking, trying to figure out what happened. So it's helpful to think about the way a court or the way a jury would look at a dispute as you're going through your relationships in your supply chain. So if there's a dispute, how's a court going to look at what happened? And the first thing that they're going to do is look at contracts. And obviously within the supply chain, the better your contracts, the better positioned you are to be able to show what was intended, what the parties were supposed to do. So within contracts, things that are very important is to think about what the specifications are for what your contracting partner is supposed to do. And whether the more detailed those are, the better. And if they can't be that detailed, even having simple quality indicators, product descriptions, and even pictures are helpful when you're looking back to see what the parties intended. Here, with respect to trade secrets, you can also build in protections within your contracts and put in restrictions with your partners to protect confidentiality, to contractually prohibit reverse engineering or decompiling of software, things of that nature to help protect yourself. When there's no contract, or if the contract isn't clear, often is what's going to happen then. And what courts will do is they'll start looking to what's called extrinsic factors. And these things can be such as course of dealing, course of performance, or modification to the contract. So if it's not clear in the contract what the parties were supposed to do, they'll look to say, what have the parties done in the past? So if there's repeated activity and a repeated relationship with the parties, the courts will look to that course of dealing, determine what likely the parties were supposed to do. What trumps that is a course of performance with respect to the particular relationship or the particular things that's happening. If it's the manufacturing of a product, they'll look at what the parties did after coming to agreement to determine what they intended to do. And the axiom is, if you want to know what they intended to do, look to see what they did. And then the last is modification. And a modification to a contract can be express or implied. So you can either, expressly say, we're going to waive a term of the contract, or we're going to add a term to the contract, or the party's conduct can modify a term of the contract. So what that means when you're thinking about it going forward is, a contract really is a living organism and a relationship that can be managed over time. So when problems come up in the relationship in the supply chain, maybe there's a delay, a time commitment's not going to be met, or there's deviations from specifications or the specific ingredients specified in a contract. It's important to remember that courts will look back as how you handled those situations. So it's important to be very specific. If your supplier's late and you say, okay, that's okay, you also want to be clear that I will let it be late for this delivery, but future deliveries have to be back on time to avoid disputes later on that could be costly, figuring out if there was a modification of the contract.
All right. Well, Peter and George, thank you very much. This was really valuable information. I'm sure that members will probably want to contact you to follow up with additional questions. So I'll be sure to include your contact information in the video description once we get this all set. So thank you very much for your time.
Great. It was great to talk to you.